Hi, everyone.
Hello.
Hello.
Thanks for joining us today.
Okay, good afternoon, dear participants. Thank you so much for joining us today again in our webinar. We are fortunate again to be joined as speakers by Mr. Amardeep Singh too, and also his partner, Mr. Chng, Keng Long. They are both from Hishammuddin, Allen, and Gledhill. They are qualified, obviously, advocates and solicitors. So before moving on to the topic for today, which is trade secrets and intellectual property in remote employment, which is a very, very interesting and very relevant topic today. I shall just briefly introduce our speakers to you. Mr. Amardeep, whom you will all be very familiar with, handles both litigation and advisory matters in all aspects of employment law and also industrial relations. He also advises corporate clients on immigration laws and management on the foreign workers and expat rights, as well as employment-related tax laws in Malaysia. Mr. Amardeep is a graduate of the University of West of England, Bristol, and a member of the Honourable Society of Lincoln's Inn. Amardeep was called to the Bar of England and Wales in 2012. He was admitted as an advocate and solicitor of the High Court of Malaya in 2013. While our next speaker, his colleague, Mr. C.K. Lang, is also an advocate solicitor, as I mentioned. Mr. Leung is a litigator with experience in various contentious matters involving international arbitration, corporate, commercial, and securities. Presently, practicing primarily in intellectual property law. Mr. Leung handles advisory and litigation work pertaining to the full spectrum intellectual property matters. So we got an expert on intellectual property here. So consider yourself very lucky. Mr. C.K. Leung read law at Cardiff University, UK, and is a member of the Honourable Society of Lincoln's Inn, the same place where Mr. Amardeep apparently obtained his, he was a pupil of Lincoln's Inn as well. And he also holds a degree in professional accountancy, Masters of Law. He was called to the Bar of England and Wales in 2013, admitted as advocate and solicitor of the High Court of Malaya in 2014. Okay, thank you very much. Without further ado, I'll leave the floor to Mr. Amardeep and Mr. C.K. Leung. Thank you.
I think my slides are my slides being displayed. That's fine, right, Umi?
Yes, looks fine.
Yeah, okay. Thank you, firstly, IR Law, Vishnu, for a very nice introduction for both me and my colleagues. Also, thank you, Umi, for arranging this and for having us today. And thank all of you all for tuning in. I know it's not the most ideal thing to have a webinar at 3 p.m. You're probably interrupting with your tea time. Today, what we will do is I will start off with addressing how an employer may protect their trade secrets and intellectual property. And with me, I have my partner, Mr. Leung, C.K. Leung, from the IP department, and he will then address an employer's legal recourse in the event there is, for example, an unauthorized disclosure or usage of the trade secrets and intellectual property. So let's start off with why remote employment poses why remote employment poses a risk to trade secrets in IP. As we have seen, as we all know, we are going through it. The pandemic has been going on for more than almost 20 months now. Employees have been working remotely away from their physical office without supervision. in-person supervision at the very least, and perhaps sometimes even outside of company networks. And this has been going on for almost 20 years. They do that while still in possession of your valuable trade secrets and also confidential information. Whether you work in a traditional work environment or you work remotely to a business, your intellectual property and your trade secrets always remain valuable assets. And when you have a work from home setting, many employees have adopted various different practices in performing their work remotely. It is not what we saw 1 year ago, or at least now 1.5 years ago. And these new practices may be working from a cafe, maybe downloading documents on a thumb drive or printing documents, can create new and increased threats to the protection of your company trade secrets. And that's where we're going to take you through today. What can you do and how can you protect your trade secrets? So the first one is, what happens or how is the risk increased? So before you put in measures to even address how you can protect your trade secrets, I think what you need to do is recognize the threat, right? So the first thing is you have less visibility over communication. Previously, your meetings used to be in-house, right? You would arrange a call, you will arrange a meeting with your client or with a third party. The third party will be in your office, you will sit down, you will discuss. It all happens within the confines of your office. Now that has been substituted with Zoom calls, right? And there is lack of supervision over these employees. Employees now can actually take a call with a third person without having to worry about the third party actually coming to the office, meeting the supervisor. Now that creates an increase of heightened risk as well. Now, I have an example of a case, and this took place in the US. And what happened was the company arranged sort of a webinar, right? And the idea was for people who have expressed interest in the company's franchise, right? And the defendant was one of them. The defendant joined the Zoom call. And during that call, the plaintiff had informed participants, which included the defendant, of various different things, right? One of it being its sales pitch as well. The defendant subsequently very smartly joined the call, very learned defendant. The defendant later started his own business, right? And he used the exact same pitch as the plaintiff had used, right? So then the court had to assess whether it was a trade secret, and if it was a trade secret, was there any breach? So here the court at the onset said, no, fine, this is not a trade secret. But the court said, even if it was, assuming that it was a trade secret and it could be protected, we will still not protect it. We will still not say there has been a breach, simply because the plaintiff did not take reasonable steps to protect themselves, right? So what the court took into account was, firstly, the plaintiff himself had freely given away this information, right, to anyone. All you had to do was click the login button, hear the webinar, here over Zoom, and the plaintiff has also then used the same code for all its webinars. And the defendant, again, very smartly, joined all the webinars and heard all the information it required. The plaintiff also didn't password protect it. So what the court said was, if you're not going to take reasonable steps to protect your own trade secrets and your confidential information or your IP rights, I'm not going to do it for you, right? I'm not going to say it's IP rights. So what will then happen is some other examples of how the risk is increased is, of course, there's inadvertent disclosure. This can simply happen from sharing devices. And I remember a case that I did many years ago, and the company took legal action against the employee because what the employee had done, and this we're talking about is 4 or 5 years ago. 4 or 5 years ago, the company, what had happened was the company picked up that the computer, which is the company laptop, had been used to log into, to do work for another company. And then they investigated, and after investigations, they found out that the wife had actually been lending the laptop to her husband because his computer had crashed. And he had been using the laptop to do work for the company, for another company. And the company took disciplinary action against the wife. And one of the reasons was because there was confidential information. She was actually part of the HR department. Unfortunately, she was part of the HR department. The call looked at it and said that you're from the HR department. You yourself know that you're not supposed to be doing it. You yourself know right on your desktop, as the IT department had shown, right on the desktop itself, there were details of people's salaries, right? There was a whole Excel sheet of people's salaries. I said, no, this will not be allowed. So the other one is sharing of devices. Data security parameters being relaxed. For example, we know when we are in the office, we use a secured network. There is no risk of a data breach, or at least the risk is much less when we use public networks working in a cafe. Unauthorized copies being made without adequate level of security being applied to their storage. I think this is more relevant, for example, if, even when the first MCO happened, well, I work in the litigation department. So whatever information that I have, any court documents that I have, anyways, is already in the public domain. But imagine if I bring in, I'm working in the corporate department, right? And I bring back a contract of M&A between two companies, right? And I leave it, I have it printed, I leave it on my desk. While it might not be a trade secret, someone walks into my house, sees that confidential information on my table, and now says, you know what, I'm going to punch this, and I'm going to buy the shares in that company. So you see how unauthorized disclosure can take place simply by leaving a document lying around. The other one, very common, where many times employees have been dismissed, is sending company information to personal email addresses. And employers, for some reason, do not pick this up. So in other words, the IT department do not pick it up, or that such practice is actually allowed, or there is no yearly audit. The other one is information being accessed or stored over employees' public or unsecured network. This is like using thumb drives, right? There was a case which I will come to later. There was a case where an employee took out trade secret and had put it on a thumb drive. Subsequently, it was detected. When the company approached her, asked her for her to return it, she obviously claimed that, you know what, I didn't do it. Subsequently, the company showed her and said, this is what our IT has picked up. And in fact, even told her it's on a Kingston thumb drive, and even told her the other brand. And she then admitted, yes, fine, I have done it, but I can't return it, unfortunately, because it has been stolen. And the last one being related to the previous one is the use of non-issue work devices using laptops that are not issued by the company, probably does not have the sufficient antivirus or network protection. So I've got three cases, right? So the first one being case examples. The employee had transferred trade secrets and proprietary documents to his personal email account and attempted to hide his wrongdoing. Here, attempted to hide his wrongdoing. The employee actually just said, no, I didn't do it. Company then pulled out, called the IT department, had a look at it, very clearly could show that emails were being sent out from the work email to his personal email. So what the court said here was, of course, it is quite rightly a dismissal with just cause and excuse. He had placed the company in a real danger of a potential risk of losing their trade secret and exposing it to third parties. There is a reason why you're not supposed to take the trade secrets out from the company itself. There is a reason why you're not supposed to send it to your personal email. There is a reason why the access to it is restricted. The next one being is here, very odd case. So I would say the employee was borderline careless, negligent, and maybe even lazy in his communication. What happened was the employee received a call. He received a call from a reporter asking about his client's plan on disposal of a manufacturing operation. So in other words, he was involved in the disposal of a manufacturing operation. And when he received the call, what he told the reporter is, you can refer to the Edge report or the Edge article, which will tell you all about it, right? So he actually didn't say it, nor did he disclose anything. The court held that he had inadvertently, carelessly, or negligently disclosed the client's information. Of course, the court held that the dismissal is with just cause and excuse. And as a senior employee, only the highest expectations were expected from him. The last one being a most simple case, an employee just simply casually sharing his password with his superior, right? And the court held no, the policy was very clear. You cannot share these passwords to your computer or to access the company system with anyone, right? And anyone means even your superior. There is no reason why you should share it with your superior unless you can tell us one, right? Unless you're directed by the company to do so. The court held that his actions were actually increased. You can see how three very different cases. One, very casually sharing his password. Second one, merely receiving the call, not in fact telling anything, just telling someone you can just refer to something else. And the last one, just sharing his personal email. There was no actual usage. So you do not need to show that the employee actually had used his trade secret with the intention to disclose it to a third party to show that the dismissal is with just cause. As long as you can show that he has handled it not accordance to your company's policy, not in accordance to your company's policy, that dismissal will help to be just cause. So employees have changed their style of working. But I guess the question as employers should ask ourselves is then, have we remained stagnant, right? Have we maintained our old policies? Have we re-looked our policies and see whether there is a need to tighten it, right? In some instances, maybe even consider introducing new policies, like a work from home policy. So as an employer, you need to ensure that your current measures always stay up to date, right? Such as your policies and SOPs adequately now protecting your interests when employees are working from home. And the four very simple ways of doing it is, firstly, of course, a non-disclosure agreement. Every time an employee joins your company, have them sign a non-disclosure agreement. I'll come back to the importance of that. Of course, the other two is linked. Have an express confidentiality clause or non-disclosure clause in both your employment contract and also your employee handbook. And the last, but definitely not the least, is when your employees leave the company. This is something I don't see being done by many employers. Remind them of their ongoing obligation of confidentiality and to not disclose the trade secret. That is a simple notice you can issue to employees. Now, why I find that very important and very effective is this. In every employment contract, you will see maybe an average of 20 clauses, right? 20, 21. If you include a confidentiality clause there, it is one of the 20. It doesn't show the importance that you put to this clause. But when you get an employee to sign an NDA or a confidentiality agreement, however you word it, it signifies the importance of protecting your trade secret. It signifies the importance of your IP rights, right? And the seriousness in the event your employee breaches it. Similar to issuing a notice of ongoing obligation of confidentiality when your employee resigns. It's a simple notice saying that this is your last date, we understand. Please note that you have signed this employment contract. Your employment contract clearly states you have these obligations, or that it's implied under the law that you have the following obligations and you cannot disclose the company's trade secrets or IP rights. Now, having the clause merely in the employment contract or the employment handbook will carry value, yes, in the event it is breached, but it may not help you in the event you're trying to prevent such breach. So, more practical measures. What can you do? Of course, firstly, you can draft a work from home policy. I think this is one of the measures that every employer should be looking at right now. It could cover various different items, for example, authorized devices, network space at work, storage of documents, how do you store it, how do you send documents, password encrypted. In certain cases, do not let the document be printed, so you can open it, but you can't print it. Usage of remote access. For certain sensitive information, you may want to implement even stricter measures and other electronic security features. Also, non-disclosure agreements with employees and third parties. You should issue this to employees and make it necessary and make the necessary revision so you can reflect your work from home settings. You should also conduct regular training and education to educate your employees on the importance of protecting the IP rights. You should also address, when you're having this meeting, how to, well, first of all, conduct during virtual meetings. Next is interaction with third parties. For example, if your employee is interacting with the third party, information is being disclosed, execute NDAs with them. And you know, that from my personal experience itself, I've got various different employees, various different clients. And I always find it very intriguing that my tech clients always make us sign NDAs. All our other clients, no matter how big they are, MNCs, do not make us sign any NDA. So again, the importance that you put to it, if you think the information you're giving to a third party is highly sensitive, execute NDAs. Right? It can be a simple template that you can have it prepared by a legal person. Limitation of disclosing of sensitive information to only on the people that need to know basis. All these will then show that you have taken reasonable steps to actually protect your IP rights. The others is again something I mentioned just earlier. Review and update your handbook to ensure that your non-disclosure clauses and confidentiality clauses reflect a work from home setting as well. And exit interviews. Why I put exit interviews there is this is where you can use this opportunity to highlight the importance of protecting your IP rights, or the importance that company places on your IP rights. One way of doing so is this is where you can issue that notice of ongoing obligation of confidentiality. When you speak to that employee, you inform him that the company takes this very seriously. It will not hesitate to take legal action. Provide him the notice and ask him to sign off. And the last one, of course, periodical audits. I think this is very common in the financial sector. You see it also in the banking sector very often. Yeah, you can consider getting on an ad hoc basis, outside consultants if needed to carry out periodical audits. Now, for existing employees, I'm running short of time. Of course, the one very common thing is employers always ask, can we include a restraint of trade clause informing an employee that they cannot join a competitor for 6 months or 1 year or 2 years after leaving our company. Now, very clear under the Contracts Act that any clause which restricts a person from carrying out his lawful trade or profession is void, right? But it's still very common, and there's also case law for that. It is, however, still very common for employers to include this. It doesn't make it legally right. The clause is still void, but it can act as a deterrent. Of course, an employee looks at it to say very much that, you know, I've got this clause, I possibly will not join this company that's a competitor. But if he does get legal advice, it remains there. But that does not mean that you have no rights. It is, so we've got this case, a federal court case. In this case, what happened was the employee retired from his employment. He subsequently joined another company. He subsequently set up another company which did competing business with his previous company. He, of course, had signed an NDA, and the NDA did not stipulate a time limit. The court held that just because there was no time limit does not mean that it's not enforceable. Certain obligations, including your obligations of maintaining your employer's trade secrets or ex-employer's trade secrets, can go on a lifetime, right? It can be perpetual, and held that NDAs can actually be drafted to be perpetual. So now, if you're going to be drafting an NDA, do ensure that it captures that you will not only protect or not disclose its trade secrets while in employment, but also at such other time as possible, right? And do not set a time limit, right? It can be perpetual. While for your existing employees, if there has been a breach, of course, besides what Long will be addressing later, when there is a breach in Malaysia, unlike Singapore, you cannot hire and fire at will. The dismissal must be with just cause and excuse. Where there is a disclosure of trade secrets or confidentiality in a breach, there can be a dismissal on the ground of misconduct. And the test there is twofold. One, you must prove that the employee has committed the act of misconduct. And number two, you must show that it's serious enough to warrant dismissal. So what will happen is, Firstly, there will be a breach. It will be reported to you. You must then investigate that breach, during which time you can actually, or you should, suspend the employee just to limit the amount of access, just to limit the access he has to information. Then you will carry out your investigations and put up a thorough report. The evidence that you will of course be required is to ascertain firstly the information that's been sent out is actually a trade secret or IP, right? You will need possibly a report from your IT department showing that been the transfer of that information. And you must, or if you do have, showing that information that there has been usage of such information. The third one is not necessary, but if you do have it, it will only go to show that the dismissal was serious enough to warrant dismissal. And now, once you have all that information, that is when you frame the charges against the employee. You must clearly state what was taken, when it was taken, how it was taken. And you must clearly identify the trade secret which has misappropriated. Now, I've got two cases just to show you the yin and yang. The first one is the court held that the dismissal was with just cause and excuse. Here, what happened was the employee took out sensitive and confidential information relating to a company's business. How the employee did it was he took it through an external computer and she also put it on a thumb drive. He subsequently returned everything else except for the two thumb drives, which he claimed was stolen. The court held here that, first of all, the employee admitted, right, that the ideas relating to the interior design were the company's trade secret and confidential information. So there was no dispute. There was no dispute whatsoever that this employee had taken out trade secrets. The court said that there were, of course, real concerns of the confidential information being used by a competitor or being provided to a competitor or disclosed to a competitor. And the court made reference to the company's policy, which said you can't act in that manner. On the other hand, we have a case where the employee had provided information to his secretary or personal clerk to type out, which the company subsequently claimed was confidential information, and some of it related to trade secrets. The court held no. This personal clerk had actually been sitting in through the meetings, was very much aware of what was going on, and quite clearly this can't be a trade secret. So you see how the first question itself was determinative for both sides. First one is ascertain whether the information is a trade secret or not. So what are the pitfalls that you will likely face when you're in the industrial court? First one, of course, wrongly claiming that the information is actually a trade secret, IP, or confidential information. So you will need to obtain advice, right? If you're very clear it is, if there is an admission, then that is fine. But if not, you may need to get some advice whether it will fall within the trade secret or not. Next is an improper investigation, and this I see all the time. Very haphazard investigation. The last one being discrepancies by witnesses during the trial or absence of witnesses itself. So what you should do then is execute SD, statutory declaration. The moment an employee tells you that I saw that person take something out to a thumb drive, or I was present when he spoke to the third party and informed the third party this information, have them execute statutory declaration. Because your case is very much dependent on verbal evidence, right? So very much this, you could very easily get them to sign SDs, and if needed, you can disclose that SDs in court. They can't run away from the topic. They can't run away from the four corners of the SD. And if they are unable to come to court, you can still at least use the secondary evidence. And the last one being failure to take steps to educate the employees itself. This is very much, I think, relevant in industrial relations. It's a court of good conscience and equity. Unlike the civil court, which is what Long will address later, the industrial court is a court of good conscience and equity. In other words, if you come with your hands not clean to the industrial court, don't expect to win your case. So in other words, if you come to court without policies in place, without taking steps to educate your employees, without informing your employees that these are actually trade secrets and you need to protect, the industrial court may not be in. Right? The court may not be in. The court could very well say that, you know what, this is a very junior employee, he possibly may not have known that, and may actually find in favor of the employee. Okay, with that, I'll hand it over to Long. For the slides, you can email me. My email address is aft@lh.edu.com. Thank you, everyone. Over to you, Long.
Thanks, Amardeep. Just let me share my screen. Can everyone see?
Yes.
Okay. So thanks so much, Law, and all the very wonderful introduction. And so I somehow managed to squeeze in a topic or a subtopic on IP, which is very relevant to employment law, really. So I will be covering the part on, it's quite different from Amardeep's part. Amardeep is more on prevention, right? So what are the steps that you must take? What are the clauses that you must insert? What are the contracts that you must sign? So mine is always, unfortunately, my area of practice is when there's a problem. So when there's a problem that they come to me, and then they will ask the question of what do we do in cases of a breach. So relevant to today is what happens when there's a breach of confidentiality or breach of confidence, breach of trade secrets, and they're all a subset of intellectual property. Okay, so that's where I will be covering in the last half session. So very quickly, contents, I'll be covering about 6 points. Before we go into all that problems, what are the elements, what are the remedies, just take a step back and see what is IP all about, just to educate us and create some awareness. And then how we go into how and why confidential information and trade secrets are part of IP, connected to employment law. We then distinguish IP, confidential information, against know-how. So in confidential information and trade secrets, we can protect. Experience and know-how we cannot protect. So it's always a point of contention when parties go to court, right? And then we share our experiences, our real life experiences on the cases that we have dealt with. And of course, we will go a little bit into how legal proceedings take place, what are the remedies you can seek. And finally, something that not a lot of people know, how do you then, in legal proceedings, still protect confidentiality? Because the anomaly is the very reason you go into court and seek certain remedies is to protect your confidentiality. But because legal proceedings are open, it's open to the public, you know, it's the principle of natural justice. So inevitably, when you file a claim in court, and in proving your claim, you file documents, you call witnesses, oral evidence, all this will be available for inspection by the public. So it's really odd. You're trying to protect your confidential information, but at the same time, you're exposing it to everyone who can just sit in and listen to all your recipes, your trade secrets. So how do we prevent that from happening? That's the last point. Okay. So yeah, so very briefly, IP is intellectual property. It is a property, it is an asset, but it is not like a car or land or house that we own. Okay, it is something that we call as intangible, which means it's there, but you can't really see it, you can't really feel it, you know, you can't really touch it, but it's there. So what do they encompass? Your trade secrets, right? That's one of it. Of course, trade secrets, you sometimes reduce them into writing and then you copyright them. But sometimes it's really just information. It's in your head, right? Formula, recipes, goodwill. If you're in a business for 30 years, you know, you've established certain goodwill. When people look at your logo, they know it's you. You know, so all these are intangible assets. Is it new? I always have the question, because Malaysia, unfortunately, we are developing the IP law, but we are not as fast as other countries. So not a lot of people have heard of IP or how, you know, they don't really know how it works. It's not new because it started in the 1600s. very long time ago, but it has rapidly increased over the last 20 years because everything now is wireless, Bluetooth devices, e-commerce, a lot of IP issues in e-commerce nowadays. So also in Malaysia, we see really a lot of increase in IP protection. And just to give you some context, IP can be worth a lot. It's not just, it's not like a few thousand ringgit, 10,000 ringgit. So in Malaysia, a context in Malaysia, we see the sale of a trademark for teapot. The trademark itself, which of course comes together with goodwill, was worth 83 million, valued by a valuer, right? So it's worth a lot of money. So what do they include? A number of things. Patents, which means inventions that, if you create some new technology, you can patent it and prevent other people from creating the same or latching on to your invention. Trademark really is your logo, the name of your business. Copyright is, for example, if you have certain designs, industrial design is similar to copyright, but in a design format, geographical indication. Of course, we're not going to be looking into all that today. We are concerned with confidential information, trade secrets. They're not technically IP per se, but they have similar functions as IP in the sense that they are intangible, they are critical to your business. So confidential information is used synonymously. They are always interchangeable with trade secrets. They are not really the same. So that's what I'm trying to highlight. Confidential information is a bigger subset. It's a bigger umbrella. Trade secret is part of confidential information. Okay, so confidential information includes, of course, highly sensitive information such as your trade secrets, business plan. You spend 5 million R&D, all your customer list, you may have 10,000 of customer contacts, your special prizes that you have managed to bargain over the years, how you communicate counterparts over the world. Market demands, again, a lot of clients, they don't think market demand, the knowledge of market demand is important, but it is because not many know what the market wants for certain products or services. Okay, so those are highly sensitive information, but it's not only that, because confidential information really is, if you look at the cases in the UK, they don't distinguish and say it has to be very important, then it's confidential. No, it can be something very private. Okay, it can be something that is very private to you, private to your company. And I wanted to share this case, Douglas and Hello, is a UK case where it's a very powerful couple. They had their very lavish wedding and they appointed photographers, and the photographers came, took their photos and tried to sell the photos. So the question there is whether the photographs of the wedding of the powerful couple can be protected as confidential information. The court say yes, the UK Court of Appeal. So it doesn't need to be R&D or trade secrets. It can be something as minor as just your photos. Okay, but if it's confidential to you, it can be protected. Of course, unavailable in the public domain. It cannot be readily available. Otherwise, it loses that element of confidentiality. Trade secrets, I've touched a little bit on it. Subset of confidential information, but trade secret is really secret. It is something that is very valuable to your company. It gives a competitive edge over competitors. It is something that allows you to be competitive, remain competitive, and they contain many sensitive information. So trade secret is really not about your personal photo or wedding photos. This is more than that. It is a subset of confidential information. So I'm not going to bore you, just to give you a little bit of context what trade secrets can be. If you look at that the first paragraph here, so trends of mail order sales. So that's market demand. Percentage of returns, sources of manufacturers. You personally know the manufacturers, plans, dialogues, catalogs, and so on and so forth. So all these are trade secrets. That's what the Court of Appeal held in the UK back in the 1978. So are they the same? They are not the same, but they are not technically the same, but they are both protected. Okay, just that confidential information is something wider. Trade secret is something more specific, something more highly sensitive. And what we have to be very careful is when we go to court, more often than not, when we go to court, we are plaintiff, and then we are suing someone who is named as a defendant. More often than not, they will say that there's nothing so confidential about the information that you say is protectable. You know, it is all about it's about skills and experiences that they have acquired over the years of working. So it is something that I think the test is really whether the skill is transferable to a different employment. So if yes, then most likely that it is a skill and experience because you can transfer the skills. But if it's not, if it's, for example, a recipe, you know, it is not something that you can use your own knowledge and go to a second job and then you can create it, then it will be trade secrets. So the courts, they demarcate very clearly skills, experiences, know-how that an employee has acquired over the years. They are not confidential information, right? So you cannot stop your employee from using or exercising his or her skills when he leaves your employment. Okay, very, very fine distinction. So just want to share a little bit. Deep went a lot into cases that we cited. I mean, one of the cases that Deep cited, Dynacars, just to let you know, is also our case. It's a Hishammuddin case. We were the successful counsel. So what are the scenarios that we always see? It's quite wide, but if I can break it down into two, it can happen when they are still employed, where they divulge your secrets. They sometimes sell off your trade secrets. I mean, for example, I was just speaking to a property agent yesterday, and I found out that I don't know, if you buy properties, you will realize that, like condos, you realize that sometimes 2 months later, people call you, and then they say, don't know how they got your number. They say, hey, by the way, do you want to sell your unit? Because I have a ready buyer, you know, I know you have a 3+1 bedroom. We have a lot of buyers for that. The market demand is very high. The question is, how did they get your information? I got to know yesterday that unfortunately, your numbers and your details are now being sold in the market for 50 ringgit. So it is definitely a divulging of confidential information, right? While still in employment. Second scenario really is also very common. They don't do it while they're with you, while they're still employed with you. But what they do is they secretly store all your secrets, all your customer lists, your confidential information, your recipes. They don't divulge first, but they take it with them. So when they leave you and they go to a different company, a lot of times they set up the company and they use those information. Sometimes they also join a different company. Also, they misuse the information. So really, 2 prongs, okay? Experience, just want to share my experience of what can happen. This is very similar to a case that Deep shared. I managed to settle this case about very recent case. This happened about 1.5 months ago. Okay, while we're under all this pandemic, everyone's working from home. Everything is just virtual. They don't see each other. So one of the key employees, it's an engineering can't see my own slides. Engineering consultant company. It's an international company, so they have a base here in Malaysia. So they hire key personnel in Malaysia, and after about 2 years, the employer tendered resignation. Normal, served the notice about 2 months. Normal, no biggie. But 2 days before he left the employment, he forwarded almost all his emails, important emails, to his own Gmail account. So I put there more than 500. I know the exact numbers is 622 emails. So they contain various things. They're not specific to any category of trade secrets, but they contain a lot of confidential information, project documents, safety information reports, accidents. And I didn't put it in here, but even things like COVID reports, COVID tests, very sensitive information, which employee has COVID and what are the quarantine measures they have taken. So all that, he took it. Luckily, the company has resources. So what they do is they will investigate the account, and they investigate the laptops for all employees that will resign or are resigning, and they found out that this was done. So client was very adamant of suing, but we managed to resolve it by way of a cease and desist. So I will explain a little bit more about it later. Experience number 2, this happened about 2 years ago. Pharmaceutical company. It's a very sad case because the company originated in Singapore. So again, they have a base here in Malaysia, and it's not a very big company, but they sell a very niche products for medical supplies. Very, very niche. In fact, I think in Malaysia, only a few sells the same products. So what happens is the Singaporean owner, of course, can't travel, can't be here all the time and be there all the time. So he mostly is in Singapore, and in Malaysia, he leaves it to his number 1 man, who over the years, of course, has moved up the ranks, was running the show in Malaysia, was just running the company, was just doing sales, was just making profits for the company. So that manager then decided, they should actually sell it for their own profit. So they set up a new company. The company is in KL Central. They sell the same products. Okay, and then over the years, because there were a lot of sales, so the manager stole certain products and sold it to some new customers, some existing customers. If you ask me how did they do it, what the manager did was he said, I've sold it to individual or company A, but company A never pays. So he said it's a bad debt. But in actual fact, he took the product and sell it elsewhere and got the money. Okay. So of course, he also was misusing the company's same thing really, customer list, pricing strategies, marketing strategies. It's a very specific knowledge for this company because, like I said, it's a very niche pharmaceutical medical supply product. Not everyone knows how to order and what is the market demand in Malaysia. Okay, so he has been doing all that for years. Company is still making money, but not as much if he had sell it properly. So then I think the catalyst happened when he left the company and joined the other company, which is his friends. So how do we know it's his friends? Because the Singaporean company, the owner, did a Facebook search, and then he saw that they all were friends. They attended each other's weddings. There are a lot of friends together. So it's all really public, information from the public domain. So 5 days before he left, he went into office. I think it was on a Sunday. He firstly destroyed CCTV. So there's CCTV in the office he destroyed because he knows exactly where they are because he's the boss there, right? He didn't steal hard disks, but he destroyed. He destroyed all the hard disks. So he was the next Monday, when the Singaporean boss received a call from another employee and say, you know, something bad happened in the company. Someone came in and ransacked the whole place. So again, the Singaporean company, Singaporean company then discovered this because he thought it is something really amiss. It's very unusual. So he made all the police reports, hired investigators. He paid a lot of money for experts to retrieve the data of the hard disk. So luckily, they managed to trace all the data. And so as he was trying to sue this person and gather more information, suddenly someone came in and applied for a job. It's just, it was a lady applied for a job. So she was employed, but within 1 week, the company realized she doesn't know anything at all about the job, right? She wasn't performing at all. So they did another investigation on her. So she said she graduated from a certain university. So they called the university and they realized that no such person exists. The degree was falsified. I don't know where they should print a certificate. And then the company did a further search also from Facebook. Again, Facebook is very dangerous, and realized she's very good friends with the ex-manager. So they're all one gang, you know, they went to the same wedding. So he couldn't take it any longer and he appointed us and we sued everyone. Okay. Again, we were successful in this case. Last final experience, hardware and engineering company. This case is still pending at the Court of Appeal. In fact, we are arguing it next month on the 18th. A very interesting case. Factually, not as interesting as experience too, but the legal issues that arise was very, I would say, law changing, game changers, right? So here, similarly, high rank employee, we called him a guru. While he was still working with us, he divulged certain confidential information to a competitor. So he used his email and he sent those emails. He was helping them do work. But the work that he did for the other company was to place orders for certain products. And the information that he used to place those orders are all confidential information, because similarly, because it's a very niche market, it's not a situation where me or you or Amardeep can just go in and place orders, because we wouldn't know what orders to place, right? We wouldn't know what are the market demands. We wouldn't know what, you know, in a specific, for example, pandemic time, certain products are of higher risk when they come and therefore lesser demand. Certain products are of higher demand. None of us will know that except for himself and the group, right? So he helped a competitor to place orders, and then he resigned and joined that same competitor company. Again, all these were discovered after the work PC was investigated. Again, have to spend some money and appoint a private investigator. Again, sued everyone. And like I said, we are still battling this at the Court of Appeal. Okay, I'm also running out of time. I'll go a little bit faster. So yeah, so next, after we have seen all that, we go into how do you sue someone really for breach of confidence or breach of trade secret, confidentiality? What are the remedies you can take? So Deep Spark, remember, Deep Spark was about, or you know, what are preventive measures you can take? A lot of things you can do. But mine is where what happens if there's still a breach, you know, regardless of all the measures that you put in. So you start off at the top, you send a cease and desist. Remember experience number one, I say I managed to resolve without going into court. It's really like a letter of demand, but it's more sophisticated. If you don't have a favorable response, you have no choice. You have to sue them because your purpose is to get remedies at the end. cease and desist is like a letter of demand. I'm sure all of us have seen it, but it's more comprehensive. Letter of demand, we can do it fairly quickly, fairly, it's very economical. It's not very expensive at all. Where we just send a letter and say, you owe us 10 ringgit, you owe us 100 ringgit, 2,000 ringgit, please pay up. A cease and desist in IP is very different. You're almost putting all your claims inside. It's almost like commencing an action in court. So a lot of details. We'll set out who we are, what are the IP rights we have. So it's applicable to trademark infringement, patent infringement, of course, breach of confidence here. And then we say, what are the things that we have, belongs to us? How did you derive it to your knowledge, and what was the misuse? And what were the infringing actions, right? And then at the end of the day, what do I want you to do? Usually we will require, of course, ceasing all the wrongdoings, stopping, okay? But sometimes stopping is not good enough. We want a bit more. Like experience number one, what we wanted was, of course, remember the person who copied 622 emails to his own personal email, we wanted him to stop divulging it to other people, but we also want him to destroy, right? And then practical reasons will come in. How do you ensure that he really destroys this and that? So that is a separate topic altogether, but it can be done. So he has to furnish video evidence of deletion and a lot of data from his PC to the satisfaction of our client that he really has deleted all of them. Okay, so that's cease and desist. If you send a cease and desist and you obtain a favorable response, you don't go into legal proceedings. You end there because you get what you want. If you don't get what you want, sometimes also happens to me. In fact, I have one now which I'm asking the client whether they want to commence proceedings, where you issue a cease and desist and they don't respond at all. Sometimes they respond and they deny liability. They say they're not at wrong. Sometimes they don't respond. So what do you do? Depends. If your situation is very urgent, for example, there's movement of monies, or there's a competitor and you feel that your trade secrets, your recipe will be divulged today, tomorrow, or in the next few days, and you don't have time to go through the normal legal proceedings, you go to court and you file an injunction. We call it an ex parte injunction. So what happens is, if you can prove all the elements of injunction, the court will grant an injunction order and say, okay, I know we are still at the start of the legal proceedings. It hasn't even started and it will take about 2 years, but pending that, the order will be there to stop the defendant from divulging information. Okay, so that's where you see prevents the infringer from continuing infringing activities until conclusion of the trial. If you win the trial, your injunction, depending again if you can prove your case, will be extended perpetually. So it will until forever. So legal action, I think some of you will be familiar. Yeah, and what Amardeep was saying is correct. It's a bit different from industrial relations courts. Here, it's the usual high court that we always see. There are different courts throughout Malaysia. Anyone can file a claim, but the burden lies on you to prove your case, right? So if you don't prove your case, you don't win your case. And as part of proving your case, you have to call witnesses. They will be subject to cross-examination. You have to produce documents to prove again your case. For example, what are the confidential information? And specific to breach of confidence, what are the elements that you have to prove, right? So this, again, the Dynacars case didn't create the principle, but Dynacars case confirms the principle, which was derived from Coco N back in the UK hundreds of years ago. These are the 3 elements that you must prove. Number 1, whatever that you say is confidential, must be confidential in the first place. You cannot simply find it in the public domain. Number two, it must have been imparted in circumstances importing an obligation of confidence. So when it is imparted to employee A knows that it is confidential. Okay. Number three is employee A then uses that to his own benefit, misusing confidential information without your consent. So very clear, 1, 2, 3 has been applied in all Commonwealth jurisdictions, all the three elements. So yeah, that's where we are. Remedies, what are the things that you can get? Going to court. Damages is compensation. You get general, aggravated, exemplary. Mandatory injunction, which is an extension of the injunction that we just saw earlier. If you win, then you get a further injunction. Depending on the type of claim, you may get account of profits, and you may get declaration that the person has infringed your intellectual property rights. Okay, I think I'm just gonna go very quickly. If you need to sue someone, we have talked about this, you need to sue someone and you don't want to divulge your confidential information to everyone, the general public, because they can come and sit in and watch the proceedings. You can file an application called confidentiality. It's called a confidentiality application, or some other jurisdictions in Canada, they call it a sealing order. They're all the same. There's not a lot in Malaysia, but we see a shift of courts allowing more and more protective orders. So even the cases here, you see 2020 and 2020, both cases in 2020 is a very new case. Back then, before 2020, we do have courts allowing confidentiality applications, but much lesser. So now I think it's a very good trajectory towards protecting confidentiality. So examples, if you want to preserve your confidentiality while trial is ongoing, you can say, for example, depends on what the judge says, or whether the judge agrees. You can say certain documents are redacted. You can choose not to file documents to e-filing system, or you can say you want proceedings to be on camera only, so no public can come in and learn all your trade secrets. Okay, that's it. Thanks. I think I'll pass it back to Deep and.
Thanks, Tom. Very informative. I didn't know about the confidentiality proceedings.
So I guess we are opening the floor for questions.
Yeah, we'll take questions now.
There is one in the chat box. Question is, if employees threaten to destroy the company data, what can employers do?
Okay, I'm assuming I'm assuming the person is still in employment, and possibly some action is taken against him, and he then threatens that he is going to destroy the company's data. Well, the first thing is, that's why you suspend them. So the moment you have taken any disciplinary action against them, if you think they may interfere with investigation, or you think there is a risk that there may be further disclosure of confidential information, you will suspend them. At the same time, you will restrict their access. Sorry, you want me to answer? Oh, okay. Yeah, you will restrict their access to the company's IT systems itself, so they can no longer do any damage to the company. And of course, then the next step would be commence disciplinary action against the employee, and if it's serious enough, you'll have to dismiss the employee.
I think I'll take the next question from Hilda. How do you protect confidentiality during legal action? As you said, public can sit in and hear the case. Yes, very good question. I think that is exactly what I was trying to cover at the last at the tail end of my talk. I guess I went a bit too fast, or you didn't get the point. It is public, but what we can try and do is we file an application to court. So when we file an application, we tell the judge and say, hey, I have all these confidential documents that I will need to file to prove my case. Can you limit access to the public? All right. Or can I only file hard copies? I don't want to file by e-filing, because e-filing, anyone can do a file search. You just pay 12 ringgit, you get the suit number, you can get all the documents filed for that particular proceeding. So we will go to the judge and we will say, we want all these measures. We want all these measures where the confidentiality must be preserved. And those are the measures, some of the measures that we can take. Again, one of the example is we limit public from participating or from coming in. The other way is we limit giving of evidence to online. So it's not even in court, it's just online, which we are doing nowadays anyway. It's like Zoom. So in that way, it's only the judge, the counsel, parties, witnesses, no one else. And that is one of the ways you can protect your confidential information. Yeah.
Hi, can I ask the questions? Rather than type. Okay, my question is, we are from an insurance company. So in insurance company, we have a business development people who are managing agents. Agents are not our employees, but this business development, those are our employees. So one of the area of concern that we have, or challenge that we have, when this business development staff moves to other competitor, he or she will bring along those agents that are managed, or those agents that is managed by him. So these agents who are not our employees, can we consider that as, I don't know whether it is a trade secret or some kind of secret, some kind of confidential info for this business development guy to use it in the new company? That is my question.
Well, ideally, if we can treat them as trade secrets, that would be the best. But I don't think we can. Well, because trade secret, they lie in the information itself, lie in the knowledge itself. So that person, you can't treat them. But I think this is more relevant where you put in place measures like how my partner Amardeep has suggested. For example, you put in NDA. So sometimes you can't stop people from moving from here to company, right? But you've got to make sure that whatever information that was channeled to them, they can't use it for the benefit of a competitor company. That's the crux. That's the main mischief that breach of confidence wants to address. Exactly your situation. Yeah. So they can go off, but they cannot use your secrets.
Okay.
I think, but this one, I think Amardeep is much more knowledgeable than me. I've seen contracts where they say, of course, when certain people go away, they also can't poach your. Yeah. So yeah, I guess Amardeep is more well versed with that. So these are all the measures that you can put in place.
I echo what Long said. And if it goes any further, for example, if the business development manager leaves the company, he joins another company, and then he wants to take along the agent, and you think he's inducing a breach of contract, then you possibly can maybe go under sort of inducement, right? Inducing someone to breach the contract itself. But I don't know whether you can go that far. I think, like what Long was saying, is that what you can do is limit, even if they leave without being able to use your trade.
Okay, thank you.
Happening, then you will obviously issue a notice of loan, correct me, cease and desist, right? Yeah, you'll issue a cease and desist to the employees to tell them to stop doing or acting in that manner.
Okay, thank you.
And I think with that, we can also take a long question from Mr. Raja. If an HR employee before leaving the company sends HR data to his own Gmail, including HR related emails, what are the options to the employer? I think here is a classic case of a cease and desist, right?
Yeah, Raja, I think very similar to my experience number one, which happened 1.5 years ago. The first thing you must determine is the data confidential? Because sometimes it's not. Not everything is confidential. But of course, a lot of things are confidential. If yes, then you have to quickly send a cease and desist in a matter, we turn around within 24 hours and quickly send and demand that the HR employee returns or deletes all that, all those confidential information. Signs an undertaking to say, I'm not gonna breach it again, right? Okay, I'm very sorry. I'm not gonna do it again. I confirm I no longer have possession of all those HR data. I confirm that I have not disseminated to anyone else. If yes, these are the people I have disseminated. I'm not gonna do it again, right? So if they sign that undertaking letter, which is attached to the cease and desist, and 2 months later you found out they still leaked the information, they actually still have those information and they were lying, it's really a matter of going to court. But your case is much stronger because you have the undertaking letter signed. Liability is admitted. So those are your options.
So I think you can address the next one as well from Charmaine. Seems to be something down the line of Dynacast.
Is there any implied obligations on employees after their employment with the company? The clause in the employment contract only mentioned only mention his confidentiality obligation during his employment. Any further remedies or action can be taken by company to protect using his new company. Yes. Yes, good question again. Is there an implied obligation? Obligation of confidence can always be implied. Best if you have expressed and you get Amardeep to go and draft the clauses on confidentiality, what they can't do, very, very long clauses. But sometimes if you don't have those long clauses, is it the end of the world? No, it's not the end of the world because you have remedy in equity, which is breach of confidential information, which will subsist after the employee has left the employment. So, and there's no time to that. It doesn't, it doesn't matter. There's no timeline, for example, to say they can't divulge for 2 years and then 2 years later they can divulge. No. The question goes back again. Is it confidential? Yes. Was it given to him in obligation of confidence? Yes. Can he misuse? He cannot misuse. So I think that's the answer to your question. Any further remedies or action that can be taken to protect? Well, unless you find out there's certain improprieties or misuse of confidential information, then there really isn't. I think in terms of measures you can take, it would be more during employment where he signed the employment contract, just make it clear, give training, make it clear to them they cannot go out and divulge your confidential information. Okay, but if you're not aware of anything, it's a bit odd to go out and say, hey, don't forget, please don't breach my confidential information, right? Unless you have an inkling or you have certain kind of evidence to show that. Okay. And yeah, I hope that answers your question.
Okay, I'll take the last one. During an online meeting, there's a record button. Company puts certain steps in allowing employees to access back the recorded meeting, but sometimes employees still can record using their own history. How to stop them from sharing or disclosing? Again, here I think it comes back to policies, education and training. The employees need to be educated and informed that this is the company's policy. If they are caught, for example, recording, or they are made aware that employees have recorded, disciplinary action can be taken against these employees. And if they want to request for such recording, they should follow the policies that the company has put in place. So again, it comes back to updating your policies. These were all not in place earlier. So you may need to relook your whether it's in your handbook, whether it's in a separate standalone policy, you may need to relook it and just update it so that it is in tune with what the reality of things are right now, which is work from home arrangement. Okay, for me, I think with that we have no further questions.
Can I have one question?
Sure.
Okay, so I'm triggered about the employee is allowed to bring their experience to outside when they are not employed with us anymore. However, for example, the employee doesn't bring the information out, doesn't send the email out, but the knowledge within him or herself. And we found out eventually the product that produced by competitor is around 97 to 98% about the same. How is that?
So if I may just can I just guess, it's a know-how going to show up? The answer.
Know how is going to show up.
At least I'm learning too now. Okay, thanks.
Yeah, well, yeah, I think, yeah, one of the difficulties is it's all about information. You see, we have to be very clear with information. It's not necessarily something that is printed on a piece of paper or is forwarded from emails. No, so the experience number 3 that the one that we're arguing next month. Remember that person was assisting a competitor to place orders. The information that he used is not tangible. It's not a piece of paper. It is in the knowledge. So that can be confidential information. Of course, our case is that there was a breach of confidential information. So yeah. So does that answer your question?
Yes, sure. So it's a breach of confidential, right?
It can be, but like Amardeep said, if it's it really depends on what type of information. Some of it, if it's merely experience and it's a skill that he can transfer to a new company. Over the years, he has learned certain skills and he goes to company B and he continues to exercise those skills, then those are know-how.
Mm-hmm.
Yeah.
Understood.
But yeah.
Okay, we've got one more last one. I'll just take it from Rafida. Confidentiality of proprietary information, non-competition clause stated in the employment contract, is it sufficient to cover the company's interest? That's the first part. Non-competition clause, I'm assuming this is you cannot work with a competitor after you have left the company's employment for 6 months. As what I highlighted earlier, this is a restraint of trade. So technically, the clause is not enforceable, right? But it's very common for employers to still include it to act as a deterrent. Now, is it sufficient? Whether it's sufficient or not, I can't possibly answer that. But what I can tell you is, it's obviously if you're an employer that wants to signify how important confidentiality or non-disclosure of trade secrets are, put up a separate agreement. Call it an NDA itself. So the employee himself will be very much aware that this is a company that takes confidential information very seriously. And you will also state in this NDA what steps or what measures the company may take against its employee. Besides just dismissal, even legal action, under the civil court for damages, for example, and that will act as a deterrent rather than just a clause. The reason being why, if it's in your handbook, for example, there are possibly 40 other articles in the handbook. If it's in your employment contract, there's possibly another 20-25 clauses in the handbook. If you really want to show them that you're serious or signify the importance of it, have it separate as an NDA.
Okay, Beverly, that's all we have. That's all time we have. Thank you everyone for joining us. Is there another message? Okay, thank you, Mr. Amardeep and Mr. Loong, for your precious time today. And we'll see you in the next webinar.
Thank you. Thanks, everyone. Take care.
Thanks, everyone.
Thank you, everyone. Thank you.
Thank you.
Thank you. See you again. Take care.
Thank you.